Good morning. Hey, it's Bernard Nomberg with another weekly episode of NOMBERG LAW Live. As we do every Tuesday, we come to you at 10 o'clock Central, 8 a.m. Pacific, and I got my buddy, a longtime attorney here in town, Jon Lewis. Good morning, Jon.
Hey, Bernard, how are you?
Good, good, and I appreciate you having a few minutes for me this morning. I know you stayed up late watching that baseball game, so, thank you for making a little bit of time. Guys, today, like we do every Tuesday, we bring to you interesting conversations with people in their areas of expertise. And with Jon, we really had to narrow it down because he and his firm here, Lewis and Feldman, do so many different things in Birmingham. But Jon and I are going to talk about lemon laws and what those mean. And it's a weird set of laws that not many people know what to do, or that the fact that they have rights when you purchase a car. And before we get into that, Jon, if you would just take a minute, tell a little bit about yourself personally and about your practice here in Birmingham.
Sure. Well, I was raised here in Birmingham. I went away to school, came back in about 92. I worked for a larger firm here in town doing mostly corporate work and then some collections work. And then I went in with my dad and I helped him with his practice. He practiced for about 50 years. He did mostly personal injury, and I worked with him for about 10 years. And then that's kind of morphed into the firm that we have here today. We do mostly personal injury type work, but I do have a niche in lemon law. My partner, Danny Feldman, he has a niche in cycling injuries. He really has a passion for cycling.
And not to interrupt you, but we're going to hear, Danny and I are going to get together in early December. We're going to talk about bicycle laws in Alabama, which unfortunately we hear way too many bad accidents and events that happen in our state. But go ahead, Jon, I'm sorry.
Sure, no problem. And you know, we've been here, Danny and I have been practicing together for about 11 years now, and that's what we do here. Personally, I have a wife, Ashley Lewis, and I've got 3 children, Alec, Lee, and Zachary. They're all, one's out of college, 2 are in college.
And Alec was a former guest of mine.
Oh, that's right. He was.
Sure, he's doing great things in the sports writing world.
So that's what we do here.
All right, I am going to push this. I'm trying to push it to your Facebook page here, and we'll be ready to go. Guys, one of the things that when you buy a car, when you buy a vehicle, you don't realize, because there's so many pages and pages of documents that you sign for the most part, whether it's a new car at a car dealership or even a used car at a car dealership. If you're going through a professional service, you're going to sign. It's like buying a house. So there's so many signatures, but who has the time or the inclination to read everything that you sign? Well, you should, even if you bought cars in the past, because those documents define what your rights are. And Jon, it's confusing for me, and I've read them many times, but I know you've handled these cases for so long. What I want to do is let's just start from the beginning and try to educate folks like me and anybody else who's watching this, including my mom. Good morning, Mom. On the process.
Sure. Well, you know, when you go in to buy a car, let me just start by saying the lemon law applies to new cars only within the first year or 12,000 miles. So a lot of the issues I come up with are people that have bought used cars or their cars older than that. But when you're going in to buy a new car, there's certain documents that you always sign. It's fairly standard. It's regulated. There are federal laws that govern a lot of it. The main document that you sign is called the Retail Installment Sales Contract, which the acronym is RISC. Mm-hmm. And that's the one it itemizes it. It's got 4 boxes at the top. It shows your interest rate. It shows your amount you're financing. It shows your interest charges. And then there's tons of language. And on the back, there's a lot of language that's in small print. And even we attorneys don't read all of that. So, you know, that's basically the main document you're signing. You usually have a bill of sale, usually have an arbitration agreement. And there's lots of ins and outs with the arbitration agreement, who it applies to and so forth. But those are the main documents that you're signing when you're purchasing a car, and the odometer statement.
And those documents that are, we would hope to protect us, really, would it be fair to say in general, really protect the seller more so than the buyer?
Yeah, you know, unfortunately, most of our laws here in Alabama, especially, seem to protect the big companies and not the individuals. But yeah, I would agree with that wholeheartedly.
Well, John, do you know the origin? And I'm kind of putting you on the spot, but why is it called lemon laws? What's that term really mean, if you know?
You know, that's a good question. You caught me on that.
Maybe
one.
it's the sour
really
taste in your mouth that a lemon
Yeah.
has. Maybe that you get that same similar feel or taste when you have a car that's giving you such fits.
Yeah, I mean, and that is, I assume that is where it came from initially. But you know, we heard it for 40 some odd years. I've just never even.
Let's talk about someone's having fits with their car that ultimately need your help. So take us through a scenario that we can kind of dissect a little bit.
Well, usually what happens is somebody buys a car and it starts having an issue that's really concerning to them. You know, it could be an engine knocking, it could be their electronic systems giving them fits, especially nowadays with all the computer systems that we have in vehicles. And so usually I don't get a call until they've taken it in multiple times and they're just exasperated with the dealer. They're not listening to them. They're telling them a lot of the comments that they'll get from the service department are cannot duplicate the issue or it's operating as a normal condition. But the person typically knows it's not. I mean, usually a person has driven, they know what's normal, what's not normal. They come to me, and depending on how many times they've taken it in, if they've taken it in the required 3 times, and that's the 2 issues in lemon law is that you either have to have taken the vehicle in for the same problem 3 times, or it has to have been out of service for 30 days. If you meet either one of those, then you can proceed with the process. And it's a very technical statute in what you have to comply with.
And so both of those requirements, or either of those requirements, that's part of the state law.
Correct.
Okay.
Correct. That's part of the Alabama lemon law.
And John, what are some examples of issues that could be applicable, like an engine
Knocking, a brake system failure. I had a call yesterday from somebody who's taking their vehicle in on a recall.
Mm-hmm.
This wasn't a lemon law issue, but took it on a recall and brakes, and then the brakes failed.
Mm-hmm.
So those are issues. Electrical issues have become a big deal where I've had where windshield wipers go on and off automatically, or the stereo's messed up, or the navigation control system, or the Bluetooth. You know, there's so many different components now that it's.
Well, there's so much run by computer, and if anything in the computer program messes up, I could see where it would create problems in other areas.
Let me say one thing about that, and one thing I try to tell people is you don't want to pigeonhole yourself.
Mm-hmm.
You don't want to say I have a problem with my window going up and down,
Mm-hmm.
when you may also be having a radio problem. You really want to characterize it as an electrical problem, and that's kind of one of the issues in lemon law is you have to have the same problem 3 times. So if you say it's my window and then my radio, and then they're going to say it's different problems. If you say it's an electrical system, then it's one problem.
Mm-hmm. It's kind of like going to the doctor's office. You may or may not realize all of the issues you have going on.
Right.
But I see what you're saying. So for the lemon law cases, for lemon laws in Alabama to apply, it's only for new cars.
Right.
Because if you buy a used car, it really is, what's the caveat emptor,
Right.
buyer beware.
Correct.
Meaning do your own due diligence on your own
Now,
purchase.
I will say the one time, there's another law that we employ with the lemon law, and it's a federal law. It's called the Magnuson-Moss Warranty Act. And essentially, it just codifies state breach of warranty claims. And I don't want to get too technical here, but if you come in with a car that's over a year, 12,000 miles, but it's still under the manufacturer's warranty, you could still have a claim. It's a different measure of damages.
And with these types of cases, assuming you can't get things worked out with the dealership or whoever you're dealing with locally, do you have to file a lawsuit to pursue your claims?
So there's a whole process you go through.
Mm-hmm.
The first process is you have to have taken in 3 times for the same problem or 30 days out of service, either or.
Okay.
Once that happens and they come to me and they employ me, I send what's called a notice of non-conforming condition, which is defined in the statute, to the manufacturer. Lemon law cases are, and this is another common misconception, lemon law cases are only against the manufacturer, not the dealer. The dealer is not liable under lemon law.
And that's a real big distinction that I think that people who are going through this need to understand.
Right.
The dealer didn't create the car. They just got the car onto their lot and now they're selling it. They didn't
Exactly.
manufacture the car. But go ahead, John.
So I send notice of non-conforming condition to the manufacturer. It gives them it explains the problems. We send copies of the service report. You always, whenever you take one of your vehicles in, you want to get a copy of the service report because it documents that you took it in that one time.
Okay.
So we send the notice of non-conforming condition. We tell them they have one final opportunity to repair. This is another thing I try to explain to clients. The longer you keep taking it in, let's say you took it in 3 or 4 or 5 times for the same problem, but you haven't sent the notice of non-conforming condition within the requisite time period, you still have to give them that final opportunity to repair. So if you keep taking the vehicle into the service department without giving the notice, you're just giving them more bites at the apple. So we send a notice, they send us a repair facility to take it to. Well, they do one of several things, actually. They'll either tell us, take it to this dealer, and they'll look at it, and we find out if they find anything on that final opportunity. Sometimes they'll send their district engineer down to inspect the vehicle. Regardless, they go through the process and make a determination as to whether or not there is a problem or there is not a problem. Inherently, that's kind of a biased procedure because they're the ones who are liable if they find their own problem.
John, let me pause you right there and ask you a couple of things.
Sure.
What is your experience telling you about how the local car dealership treats the client, the customer? They've gone through this. Their own repair department can't fix whatever the issue is. Do they wash their hands of it and say it's not my problem, or do they help the customer? What is your experience sharing or telling you about how that relationship is going?
More often than not, they wash their hands of it, or they just say, that's between you and the manufacturer. Because you got to remember, they've already been paid for the vehicle. They're done, but for working on the vehicle. Now, they don't mind working on the vehicle because they get paid by the manufacturer even for warranty repairs. But for the most part, they're not helping their customer against the manufacturer. I think they view it as more of a hassle. They look at a lot of people who complain about their car as just a nuisance.
Then once you put the manufacturer on notice and they direct you to have it looked at by X, Y, or Z, does it typically go back to that same car dealer, or does it go to somewhere else for repairs or to review it?
Most of the time it does go back to the same car dealer. Sometimes it doesn't. Sometimes somebody purchased a vehicle in a different county or a different state, and so it has to go to a different dealer. It's more convenient or whatever. But for the majority of the cases, they go back to the same dealer.
And it just seems like you're still hitting your head against the wall, because if you're taking it back to the same people, what's new in the equation that's supposed to fix it?
Well, like I said, a lot of times they do send somebody down from a regional department to take a look at it. So that would be the new. But you're right. I mean, it's kind of humorous because they're not going to come in and say, "Oh, we made a mistake in the 5 previous times we looked at it."
Right. Let's say that you go through that, and then the manufacturer sends an engineer or something. There's nothing wrong here. This is not our issue. Then what's your recourse? You haven't had your car in how long? How many weeks or months at this point?
Well,
So
it depends.
What's next?
The next process you have to do, it's another prerequisite to filing suit. One thing I do want to say is these cases are not governed typically by an arbitration, because you're going against the manufacturer and you don't really have a contract with the manufacturer but for the warranty. The contract's with the dealer where the arbitration clauses come in. And that, there's some confusion there too, but you have to go through an informal arbitration procedure, and that's promulgated in the statute. And it requires you, if the manufacturer has set up an informal arbitration procedure, you have to exhaust that remedy.
So that's before filing the lawsuit or going into a trial on this.
Right.
Now, where do those arbiters come from?
Typically, there's two places where these manufacturers set up arbitration. It is either the Better Business Bureau, which I've done numerous here at the local Birmingham Better Business Bureau.
I see.
And the arbitrators are volunteers just from the community.
Okay.
You don't know who you're going to get. You don't select them.
Wow, that's interesting.
Yeah.
It's not somebody who's certified or has an experience necessarily in this.
And I haven't looked into it, but I think the BBB does require them to have some training, so to speak. And then that's, typically I know Ford uses the Better Business Bureau.
Mm-hmm.
I know Chrysler, which is FCA, is Fiat now.
Mm-hmm.
They use the National Center for Dispute Resolution Services.
Okay.
It's kind of the same thing. You can actually, the BBB, we always have a hearing. With the National Center for Dispute Resolution, we can do it without hearing, just do it on paper, or we can have a hearing.
And where might that be held?
The hearings are usually held at the dealer. And the last one I had was at Tameron Honda with an arbitrator that they sent in from Atlanta.
Okay. So somebody who probably is well versed in these issues.
He was an engineer. It's funny, the NCDS, which is National Center for Dispute Settlement, they usually send somebody who's more engineer technical oriented. The BBB will use local bankers, lawyers, whatever. So it's
interesting.
Yeah.
Interesting. I want to pause for a second and say hi to my mom who's watching across town, Mitch out in California, Sandy, and David Haskins. Thank you, guys. We're talking with Jon Lewis. Jon is explaining to us about lemon laws in Alabama and the rights and remedies and procedures. If you've got a bad car, what you have to go through before you can get some resolution. So, Jon, let's say that our arbitration, it fails. And let's go back to our example. Let's say it's an engine. Let's say the engine just keeps cutting off. You've got a new sedan that you bought brand new. You're now 4 or 5 months into this. You're at wit's end. You go to arbitration. The arbiter rules against you and says, no, this is not an issue that is the responsibility, for whatever reason, of the manufacturer. Then what can you do at this point?
Well, let me just first say that I would say 80 and 90% of informal arbitrations, such as the BBB and NCDS, are ruled in favor of the manufacturer. So I usually do not have any expectation that they're going to rule in our favor.
Right.
It's just something we have to do in order to file suit. And we want to make sure we do that so that they can't come back later and say, well, you didn't do this, and we judge, we want you to throw the case out. At that point in time, if they rule against us, let me say one thing. If they rule in our favor, which has happened, but if they rule in our favor, it's binding against the manufacturer. It's not binding against the customer. So if they rule in our favor and we want to take it, we can do so.
What type of remedies might you be awarded?
Well, that's the problem with informal arbitration. The manufacturers set up these programs. So they authorize these programs to go through the process, but they don't authorize them to award attorney's fees.
Okay.
So the damages typically is you can either choose under the lemon law repurchase or replacement.
Okay.
So I can go into more detail if you want me to on damages.
It's for today's purposes. Let's stay out of the deep weeds and just hit the highlights.
Well, I just wanted to say one thing. They are entitled to a set off for the usage that you've had the vehicle. So, for example, let's just say you've driven the vehicle 2,000 miles before that engine problem starts occurring.
Okay.
They get a set off for that 2,000 miles.
And what's a set off for those who don't know?
So a set off, they have to, if they're repurchasing your vehicle, they have to pay you all your money back, which includes the purchase price, the interest you've paid out, any incidental expenses, your title, your taxes, all that.
Okay.
But they get a set off of the amount of mileage prior to your first notifying them of the problem, over 100,000. So, for example, if it's 2,000 miles, they get a 2% set off. So if the vehicle's $10,000, I know that's unusual, but if the vehicle were $10,000, they would get a $200 set off.
So a credit or a reduction in what they would owe.
Correct.
Well, how do you, as the attorney, how are you compensated for the work you've done?
Well, the way my contract reads in that situation, that's where they pit me against my client, because they're saying, look, we'll repurchase your vehicle, but we're not going to pay your attorney.
Right.
And my contract says you can accept that if you want to, but then you agree to pay my fee. or you don't have to accept that, and we can continue on with the process and file suit and go through litigation. I've had it happen both ways. I've had a client want to pay me because they just are ready to be done. They don't want to go through the litigation process.
Right.
I've had them go to litigation, and the manufacturer typically understands that if they lost at the arbitration phase, which is very, very rare, that they're probably going to lose at the trial phase, and they end up agreeing to pay my fee.
I see. And let's go back to the scenario. You said that 90% or so of the customers lose at the arbitration phase of this process. Then what if you still want to pursue it? If you're still wanting to go forward, are you now forced to file your lawsuit?
We are. We file a lawsuit in circuit court in the county where they purchased the vehicle.
And circuit court in Alabama is the jury level. It can be a judge, but it's also, that's our jury level,
right?
Court system, court level. So you file your lawsuit, you go through your discovery, and I won't bore everybody with all of that part, but are these cases, are they tried in front of a jury or just a judge?
You can do either one. We usually do jury.
Jury, okay.
You know, in Jefferson County, I typically don't demand a jury because the defendant will demand a jury, and they pay for it. It costs money to demand a jury, and I just make them pay for it.
And John, when you file these cases, what's your experience and how long does it typically, and I know every case varies, but typically how long does it take to reach resolution?
It's usually resolved within the first 6 months to a year if it settles. And for example, I've been handling these types of cases for over 20 years. I've tried 3 to a jury verdict. So to give you some idea, I mean, I've handled hundreds, 3 have gone to jury verdicts.
Right.
Most do settle.
Well, at some point, isn't there a tipping point with the money that's at issue?
Yes.
With the car and probably the emotional state of your client, the customer. How many have the luxury of either renting another car for that period of time or buying something, or just going from a 2-car family to 1 car and they just get to the point where they just can't handle it anymore?
It's very frustrating, and the companies have the money and the will and to drag it out.
Yeah.
If it goes to trial, my last one that went to trial took 2 years to get to trial.
Wow. And how long was that trial?
It was 2.5 days, I think.
Well,
that was back in October, actually.
Well, guys, it's when you buy a car in Alabama, a new car, must make sure that we're giving a distinction here. When you buy a new car, the Alabama lemon laws, that's what we're calling it, are going to be applicable. There's also federal law that may apply as well. Each state probably has their own version of lemon laws, and I know, John, you practice here in Alabama, but I don't know if you belong to any attorneys groups or know of other states, how they treat their cases. Have you ever dealt with other states?
Not personally, but I do know a lot of attorneys who do a lot of work around the country, and every state has their own nuances in lemon law. I know California is very liberal, whereas some other states are not.
Sure. And that's, John, I don't want to backtrack completely, but I want you to kind of give us an idea of a few different type of scenarios or examples of what has gone wrong with the car that may fit the criteria for lemon law pursuit by you.
I think most of the cases that I handle that fit the criteria have to do with the engine or transmission, where they've had to replace the engine, replace the transmission. It's still given problems.
So really something significant.
Yeah, that's the law itself uses that term, significant. The problem that you have in a lemon law must significantly affect the use, value, or safety of the vehicle. So for example, and I have had these cases before, but they're not strong cases where you have a radio that keeps going out. I mean, it's just, how much does that affect the use of the vehicle, the value of the vehicle, or it obviously doesn't affect the safety of the vehicle. It may be safer if you can't play the radio.
Right.
But so, you've got to weigh the issue with the significance of it.
Well, John, what if it's more cosmetic, but it's multiple cosmetic things? For example, the mirror, your rearview mirror keeps popping off. Paint is peeling on the back, and one of your tires just continually has issues and won't keep air. collectively, that's much more so than just these annoying 1 or 2 items, but can you have a collection of items that create that?
It's tougher in those types of cases unless your vehicle has been out of service for more than 30 days.
Okay.
Because the law is pretty clear, and that's why it's so technical. It's the same problem 3 or 4 times. So if one's paint, one's tire, one's the rear view mirror, I mean, we think of it as a lemon, but I don't think the law really
may not
considers
rise
it.
to the necessary. I want to say hi to Melissa at the State Bar. Thank you for tuning in, Melissa. We appreciate any support and you watching today. I'm talking with Jon Lewis. Jon is talking to us, teaching us about Alabama's lemon law cases, and we're getting close to the end of our discussion. Guys, and those of you who are watching us now or watching us later on, we sure appreciate your interest and your comments. Jon, if you would, if folks have a potential case, a potential lemon law case, and they just don't know, but they need to run it by you, how can people reach out to you?
They can either call our office at 205-254-6060, or they can email me at Jon, that's Jon, no H in my name, at lewisandfeldman.com. Jon at lewisandfeldman.com, or they can go to our website at alabamapersonalinjury.com.
And we'll put all of Jon's contact information in the comments section. Jon, thank you for spending some time with me
Sure,
today.
thank you.
This is it's another important area of the law that not many people know about. We've all heard the term lemon laws, but not many people have ever had to deal with this issue. And until it's your situation, you just kind of tend to ignore it. But I'm glad we've got a resource like Jon here in town who's helped out so many people with these kind of cases. Jon, anything last in closing?
I don't think so. I think, unfortunately, this is a prevalent issue with vehicles. And I will say this. Yeah, there's one other thing I wanted to say. People ask me all the time, so what manufacturers should I stay away from? And I will say that over the 20 years, the Ford, the Chrysler, and the GMs are, they may sell more cars, I guess, but they are the ones that I usually deal with. I have handled cases against all major manufacturers, but those 3 are typically the ones I see.
They seem to pop up the most. Well, guys, thank you again for spending some time with us at NOMBERG Law Live, as we do every Tuesday. Interesting conversations with people in their areas of expertise. Hope you guys have a great rest of your week, and we'll catch you another time.
We will. Thank you.